In the AP Government and Politics class, Supreme Court cases are considered especially heinous. In the classroom of John Lunn, the dedicated students who study these cases are members of an elite squad known as the Supreme Court Unit. These are their cases.
In the presidential election of 1800, the Democratic-Republican candidate Thomas Jefferson beat the Federalist incumbent John Adams. During the lame duck period before Jefferson officially took over, Adams attempted to weaken the power of the new Democratic-Republican Congress and administration by appointing roughly 60 new Federalist judges.
I reportedly signed commissions until the midnight of my last day in office.
A commission is a piece of paper that essentially awards the judge the new job. Although every judge commission was signed, submitted, and approved by Adams and Congress, not all of them were able to be delivered before Adams' term ended.
I ordered the Attorney General Levi Lincoln and Secretary of State James Madison to not deliver the commissions.
Without their commissions, the judges would not be able to act in the new positions, even though they had technically been appointed.
My name is William Marbury, and I'm one of those midnight judges who did not get their commission, so I decided to take it to court.
Marbury wanted the court to essentially order Madison to explain why he couldn't get his commission, and ultimately to just hand over the commission. Marshall, however, saw this as an issue bigger than just Marbury's commission.
Yes, Marbury has a right to his commission, and yes, Marbury has the right to remedy. However, the Supreme Court does not have the power to make Madison hand him over the commission.
Marshall ruled that Section 13 of the Judiciary Act of 1789 violated the Constitution by giving the court powers that were prohibited by the Constitution, especially issues writs of mandamus or court orders.
The Constitution is the supreme law of the land, and it is the Supreme Court's job to decide whether or not Congress or the government has violated it.
Marbury v. Madison established the idea of judicial review, which gives the Supreme Court the power to decide if a law is constitutional or not. The United States' entry into the First World War had caused deep divisions in society. In 1919, Schenck was indicted on 3 counts for going against the draft.
Do not register for the draft. This whole thing is a scam for the government to motivate this capitalist society we live in.
Schenck was exercising his freedom of speech. It turned out, during wartime, you had to be very careful with what you would normally say.
Charles Schenck will be guilty on 3 counts. 1, conspiracy to violate the Espionage Act. 2, conspiracy to go against the United States. And 3, unlawful use of mails.
The Espionage Act is unconstitutional, and my client was simply exercising his freedom of speech under the First Amendment.
Yes, but it can be restricted if the words presented to society shows a clear and present danger. Schenck clearly shows this by endangering the war effort.
Based on a unanimous ruling, Schenck will not be protected in this situation.
This court decision was later overturned by Brandenburg v. Ohio.
In 1969, Norma McCorvey, a 22-year-old resident of the state of Texas, became pregnant and visited her doctor, Dr. Lane.
Doctor, this is the 3rd time I've been pregnant in my life, and I can't go through this again. I need an abortion.
Unfortunately, Texas state law prohibits abortions unless it threatens the life of the mother.
Dr. Lane referred her to an adoption lawyer who then sent her information to Linda Coffey, a lawyer who had been on the lookout for a potential class action suit. In 1971, Coffey filed the suit under the name Jane Roe. Linda Coffey, representing McCorvey, went up against Henry Wade, who represented Dallas County. The ruling was decided by a 3-judge panel.
Women should have the right to privacy guaranteed to them in the Constitution, and the state has no authority to restrict a woman's private decision to have an abortion.
Life begins at conception. The government should be able to protect the life of the unborn child and prevent it from being terminated.
This panel declared the Texas law outlawing abortion unconstitutional. However, we choose to not enforce this ruling.
So nothing was done. Later that year, the Supreme Court heard the case. They came to a similar conclusion.
The Constitution does ensure right to privacy through the 14th Amendment. A woman's decision to have an abortion should be free of interference from the state.
Roe v. Wade set an important precedent and overturned anti-abortion laws throughout the United States. Although the decision still stands after being challenged several times, the court has recently been more inclined to set smaller obstacles to access to abortions, like requiring a certain amount of visits to the doctor before obtaining one.
During the 2008 presidential election, conservative nonprofit organization Citizens United sought to run television commercials and a documentary film highly critical of Hillary Clinton called Hillary the Movie just before the Democratic primary.
The Bipartisan Campaign Reform Act restricts corporations from the funding and airing of campaign ads mentioning a candidate within 30 days of a primary election or 60 days of a general election.
Fearing prosecution from the FEC, the organization sought a declaratory judgment in federal court to assure their right to show the movie. They filed a complaint in the U.S. District Court.
We asked the court to declare the ruling on corporate and union funding unconstitutional and ask the FEC to not enforce its regulations.
We rule in favor of the FEC due to the fact that the movie has no other reasonable interpretation other than to vote against Senator Clinton. The movie should also not be exempt from the ban on corporate spending.
Citizens United appealed to the Supreme Court, which granted certiorari on November 14, 2008. In amicus curiae on behalf of Senator Mitch McConnell, Floyd Abrams argued in support of Citizens United, and on behalf of Senator John McCain and others, Seth P. Waxman argued in support of the FEC.
The majority of the court holds that under the First Amendment, corporate funding of independent political broadcasts for candidate elections cannot be limited.
Myself and fellow Justices Scalia and Thomas agree that free speech is an indispensable part of our democracy and that bigger restrictions improperly censure this.
My colleagues, Justice Ginsburg, Breyer, Sotomayor, and I dissent. We argue that corporations are not members of society. Allowing them to spend money during elections threatens to undermine the integrity of elected institutions across the nation.
The Supreme Court's ruling in Citizens United v. FEC dramatically reshaped the business of politics in the United States. It helped unleash record amounts of outside spending that can be seen in subsequent election years and brought on the super PAC's rise to power.
In November of 2014, Court of Appeals circuits came into disagreements over whether statewide bans of same-sex marriage were constitutional. Many same-sex couples were denied marriage license because of their partnership. For example, Richard John Baker tried to get a marriage license to marry his boyfriend.
I would like to apply for a marriage license.
But the state of Ohio denied his application because he was in a same-sex relationship. Many similar cases filed petitions for writs of certiorari with the Supreme Court. The lower courts were divided on the constitutionality of same-sex marriage bans. Ultimately, the Supreme Court decided to put an end to the debate.
Not recognizing same-sex marriage is against the 14th Amendment.
The fundamental right to a marriage license is found in the Due Process Clause of the 14th Amendment, which gives everyone the right to express themselves.
It is possible that same-sex marriage bans count as sex discrimination, but I think the bans are constitutional.
It is the court's majority opinion that same-sex marriage bans are unconstitutional and therefore illegal in the United States. We ask the court to... I would like to apply for...